we're calling into session the Committee on Public Safety, Intergovernmental and Military Affairs. The Thursday, March 17, 2022, 1 p.m. in conference room 229. And with the housekeeping things first. The meeting is being streamed live on YouTube. And the unlikely event, we have to abruptly end this hearing due to technical difficulties. The committee will reconvene to discuss any outstanding business or on March 22nd, 2022 at 1 p.m. in room 229. A public notice will be posted on the legislature's website, and testifiers who are participating remotely, your audio will be muted and the video disabled until shortly before it's your turn to testify. You have, as testifiers, 2 minutes, and we will be enforcing that. I'll be reading a list of individuals who submitted written testimony for each measure. We apologize if the closed captioning doesn't accurately transcribe the names. If you're interested in viewing the written testimony, please go to the legislature's website. You'll find a link on the status page for the measure. Okay, on that note, for House Bill 1739, House Draft 1, we have the first testifier, Max Otani, Public Safety.
Hi, good afternoon, Chair, committee members, Max Otani, Department of Public Safety. We will stand on our written testimony supporting this housekeeping measure and will be available for any questions you may have.
Okay, thank you. Next, we have Mark Patterson testifying for the Hawai'i Correctional System Oversized Commission. Mark, are you there?
Good afternoon, Senator Nishihara, members of the committee. Mark Patterson, Chair of the Hawai'i Correctional System Oversight Commission. I'd like to stand on our testimony that's submitted. I will be standing by for any questions you may have. Thank you.
Okay, do we have any others who might be on the video link that may want to testify? If not,
any individuals in the room.
oh, now we can ask for any individuals in the room who have not been noted, but I see we have Kat Brady. Did you want to
Support.
Support. Well, good. All right. I see Sandy Ma here.
Thank you. Thank you, Chair, members of the committee. We submitted written testimony in support as well. Thank you.
Okay, so we have all the testimonies in written form. We have it here. So, okay, we had one individual in opposition, and the 1, 2, 3, 4, 5, 7. The rest were all in support. So, members, any questions? No. Okay, then we move House Bill 2309, House Draft 2, and we have Max Otani again.
Good afternoon again, Chair, committee members, Max Otani, Department of Public Safety. We would stand on our written comments on this measure and be available for any questions you may.
Okay, thank you. Mark Patterson. Mark.
Senator Nishihara, thank you again. Once again, I'd like to stand on our written testimony, and we'll be here for questioning. Thank you.
Okay. And we have Dwight Sakai, Deputy Chief Court Administrator.
Good afternoon, Chair Nishihara, Vice Chair DeCoy, members of the committee. The judiciary supports House Bill 2309, HD2, and we stand on our written testimony. Thank you.
Okay. Then we have Carrie-Ann Shirota, ACLU.
Aloha, Chair Nishihara, Vice Chair DeCoy, members of the committee, Carrie-Ann Shirota on behalf of the ACLU of Hawaii. We strongly support this measure. We believe that successful reentry and reintegration takes a village, And we know that there are many nonprofit organizations in our community that are doing the work. They often operate on shoestring budgets, and they would benefit from funding from the state because they are working in partnership collaboration to help people successfully transition back home to become contributing members of our families. We humbly suggest some amendments to strengthen this already wonderful bill, that you consider including an appropriation for also the Department of Human Services and Department of Health. Both of these agencies have expertise in assisting people with health, behavioral health needs, housing assistance, SNAP, and other types of human support services that are needed. And it really should be the kuleana of all different agencies. We see that it was expanded from Department of Public Safety to Paroling Authority and Judiciary. We also would like to suggest DHS and Department of Health. And finally, we humbly ask for a requirement in the bill that there be an annual report, how the appropriations were expended between these agencies and passing through to the community, how the funds have been used, the list of providers, how many people have been served, description of services, measurable outcomes, and perhaps any barriers that the nonprofits may face in executing the appropriations. And I mention this because this is information that's valuable for you as lawmakers and policymakers as you weigh budgets and where you put money into, and really moving to a performance-based budget. Thank you so much for the opportunity to testify in support of this measure. Mahalo.
Thank you. Next is Nicholas Leverance, testify Hawaii Health and Harm Reduction Center.
Aloha, Chair, Vice Chair, and members. My name is Nicholas Leverance with Hawaii Health and Harm Reduction Center. I'd just like to underscore the real importance of pre-release planning for those exiting carceral facilities, particularly prison, and the obtaining identity documents that are vital to obtaining needed medical care, housing, and other government assistance. So this bill is a real important step in the right direction. Mahalo for the opportunity to provide testimony.
Kath Brady.
Living color. Aloha, Chair Nishihara, Vice Chair DeCoy, and members of the committee. Kat Brady testifying on behalf of Community Alliance on Prisons in strong support of this measure. I really love this because it talks about pre-booking and post-release. So it's the first bill I've ever seen that actually looks at the whole Megillah. So I think this is really, really important. I love the recommendations of ACLU and support them. Please pass this measure. Thank you.
Thank you. Okay, we have, I believe we have, let's see, Carolyn Eaton. Are you there, Carolyn?
I'm right here, yes. Good afternoon, Chair Nishihara, Vice Chair DeCoit, and members of the committee. My name is Carolyn Eaton, and I support this bill wholeheartedly. I have no trouble imagining the valuable changes which would come out of this initiative. Our state holds so many individuals who should not be imprisoned, but diverted to receive the particular care their situation requires, be it mental health care, addiction treatment, or houselessness. Taxpayers should no longer pay for housing such individuals in jails and prisons. As taxpayers, we bear complicity also in the wrongs done these individuals currently. End this shameful practice, please. The welfare of the entire community will benefit. Thank you for your work.
Thank you, Carolyn. Any others who are on video that haven't been mentioned would like to testify in this bill?
Yeah, my name is Peter Coolidge. I believe that I requested to testify live as well as in addition to my written testimony on this bill. Yeah, my name is Peter Coolidge. Could I go ahead with my testimony?
Yeah, please do.
Great. Thanks for letting me speak. I am in support of HB 2309 and support the recommendations for proposed amendments by Carrie Ann Schroeder of the ACLU. I think that appropriating funding for the development and maintenance of diversion, reentry services and programs is a move that reflects both the moral values of the community and works to solve longstanding problems with the state, which relates to extensive budgetary commitments that are made to fund incarceration. I think the more we expand services to folks exiting the carceral system, the more likely it is that they'll be able to find stability within the community and avoid further entanglements with the criminal legal system. So I do ask that you pass this bill and add the amendments proposed by the ACLU. Thank you.
Any others on the Zoom? If not, any members in this live here would like to testify? We have several comments from Kathy Betts from Department of Human Services, sent in comments. Craig Rye sent in for BNF, sent in comments. And the majority of the rest were all in support, with the exception, I think we had one opposition. So I think that takes us through this. There was 27 in support, 1 opposed, and 3 comments. So that brings us to the next bill. But before I go further, I'd like to introduce the members of the committee. We have my Vice Chair, Linda Coit, on my left. And to her left is Gil, I'm sorry, Gil Revere. Thank you. Mental block. Okay, and we have Ross Baker. Okay. So we're moving on to House Bill 2312. We have Kara Jabolis. Kara there? Oh, she's not there? Okay. Max Otani?
Good afternoon again, Chair, Vice Chair, committee members. Max Otani, Department of Public Safety. We would support this measure and would be available for any questions you may have. Thank you.
Okay. And Nicholas Leverance.
Aloha, Chair, Vice Chair, members. Nicholas Leverance on behalf of Hawai'i Health and Harm Reduction Center in strong support of this bill. And I would just like to comment that measures like this should also consider the fact that we need, to reform sentencing laws and probationary practices that unnecessarily overpopulate our carceral facilities. Mahalo for the opportunity to provide testimony. Thank you.
Jennifer Walsh.
Good afternoon, Chair Nishihara and Vice Chair Lynn DeCoit, and members of the committee. Good to see you. I'm Jennifer Walsh. I'm testifying on behalf of the Women's Prison Project in strong support of this measure. We know that the criminal justice system, the justice system in general, is set up really to address the offending behavior of men, since they make up the vast majority of participants in the system. Yet women have unique needs that really need to be taken into consideration. There are decades of research that show that by tailoring programs to women, we can not only better affect their outcomes, but also affect positively the outcomes of their dependent children, who often end up in foster care for women who are incarcerated, even though they don't pose a threat to the community. This commission will really help to tailor policies and procedures and programs to meet the unique needs of Hawaii women and therefore have better outcomes for all. We are recommending 2 amendments. One is to add a member of the Public Defender's Office to the commission membership, and also to make sure that everyone understands that membership should come from all counties in Hawaii, not just Honolulu. Thank you again for the opportunity. We have written testimony in support of this measure as well.
Thank you, Jennifer. Any others on screen that would like to testify? If not, any in the audience? Well, we've had comments from Craig Hirai, Director for BNF, and Rodney Miley for the judiciary in testimony. And there were two others that had sent in support letters. There were 5 support, 0 opposition, 3 comments. Members, questions? Otherwise, it'll be House Bill 2344 and House Draft 2. And we have in person, Kath Brady.
2344.
Yep, 2344 House Draft 2.
I think Nikos Leverance was actually testifying on the probation bill. So, okay. Could have been just a typo. Thank you so much for hearing this bill and the opportunity to testify. Community Alliance on Prisons is in strong support of this. You know, the growth of the probation population has really burdened the system. I mean, we have like 18,000 people. It's crazy. So how can a probation officer spend time with somebody to help them when they don't have time? So that's kind of crazy. One of the key drivers of our probation system is the length of our sentences. And Pew came out with a report that showed Hawaii has the longest probation sentences in the country, 59 months. This is insane. So the most recent data also shows about 18% of the people in jail are there for a violation of probation or parole. And in Hawaii, it's 22%. So we have a large population of people who, you know, either didn't show up for a meeting or tested dirty, you know, things like that. So it just seems crazy. It's very expensive. It's more than like about $89,000 a day and $29 million a year to keep this population incarcerated. So right now, probation is the most common criminal sentence in the United States. So we have to really look at what's going on and what are better ways to deal with people who are having trouble complying with probation. The research shows that incarceration only increases criminality, and we don't want to do that. I think equitable and humane treatment could go a long way to helping people actually figure out how to behave in the community the way that we really want them to. So thank you very much.
Thank you. Okay, now we have Brooke Mamizuka from the Judiciary.
Good afternoon, Chair Nishihara, Vice Chair, and committee members. Brooke Mamizuka, Probation Administrator for Oahu. Also with me is Craig Hirayasu from Maui. Probation Administrators, Dean Hiraki from the Big Island, and Renette Garma from Hawaii also submitted written testimony in support of this bill. It is recommended that review and early termination be conducted on probation cases, with the exception of cases involving habitual operating vehicle under the influence, possession of firearms, domestic violence offenses, and crimes against persons. These types of cases involve deceased victims and their families, and are victims that have suffered physical or psychological trauma. Thank you very much for your time, and I'm here for any questions.
Next, we have Lee Hayakawa.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I am Assistant Public Defender Lee Hayakawa. While the Office of the Public Defender supports the intent of HB 2344 HD2, the Office of the Public Defender has reservations and concerns regarding the bill in its current form and whether this bill will make any real difference for individuals on probation. We urge this committee to reinstate good time credit and the prohibition of revoking probation based solely on technical violations. Thank you for the opportunity to comment on this measure. I'm available for questions.
Thank you. Tricia Nakamatsu, Office of the Prosecuting Attorney. Tricia.
Tricia is not. She's not on the Zoom.
Oh, she's not on Zoom. Okay, well, we'll move on. We have Nicholas again, Reverend.
Good afternoon again, Chair, Vice Chair, and members. Nikos Leverins on behalf of Hawai'i Health and Harm Reduction Center. If I do sound repetitive, it's because these issues are very much interrelated. And in this case, we agree with the Public Defender's Office that this bill should be amended to preclude technical violations of parole in a manner similar to that passed by your committee in SB 2514. So we hope that this committee will consider reinserting the amendments proposed by the ACLU into the bill in order to reduce the number of people in our carceral facilities, including women. Thank you very much.
Thank you. Peter or George.
Thank you, Chair. I too am speaking in support of this bill under the condition that it's returned to its original form so that we can include an end to incarceration for technical violations and to create the good time credit system, as well as prohibiting imposition of certain unreasonable probation conditions. Without these provisions, I don't think this bill will bring meaningful change to the system, which does need substantial reform. We're obviously considering spending $1 billion on a new jail when we can really be approaching the problem in terms of how do we get folks out of the carceral system and how do we set them up for success within the community. I think that bringing back those original provisions can set us on the right path, headed towards that direction. And that we should be thinking about this in terms of what's the best available data to understand what the consequences of this action would be, rather than kind of intuitions or conventional wisdom. And I think that the data provided by the ACLU and Carrie Ann Schroeder has shown that this and other strategies to decarcerate have generally led to improvements in conditions without any kind of increases in crime. So I am asking that you pass this bill with its original provisions. Thank you.
Thank you. Any others on video that would like to testify?
Yes, Senator. Sorry, I did submit testimony, but I missed it by a minute to select the option to virtually provide testimony. So aloha, Chair Nishihara, Vice Chair DeQuate, members of the committee, Carrie Ann Shirota on behalf of the ACL of Hawaii. We strongly support the original bill measure, and yet we see some compromises here. So let's just start off with the big picture. This bill is intended to address reforms that have been implemented in other states with positive outcomes. As Kat Brady mentioned and others, about 20 to 25% of the people who are in our jails and prisons, even including those in the federal detention center, those who are sent out to Saguaro prison out of state, are there for probation and parole violations. The majority are for probation violations, more so than parole. While the ACO does not oppose requiring probation officers from conducting this halfway review that could result in shorter probation supervision terms, it is not a substitute for taking a systems approach to reduce incarceration for revocation and providing an earned time credit system for compliance with conditions of probation and supervision. We need to create laws that are driven by data, and I'd like to highlight a few. It's already been mentioned that Hawaii has the longest rates of probation, and the longer that someone is on probation, there is more of the likelihood that there may be a technical violation. The second data point that I'd like to also highlight to you is that this is based upon information provided by the commission in their testimony, that in a given year, I think it was this last fiscal year, over 490 persons have been revoked, 495 technical violations. Now, even though that is statistically a small percentage of the people who are on probation, which means that the probation officers are working with people to keep them out of jail and prison, which is something to be applauded, that 495 technical violations, which can result in incarceration, cost taxpayers money. If we multiply 495 people times by $219 a day, multiplied for 365 days a year, that amounts to more than $39 million that we are paying. Critically, there's data to suggest that there is no evidence to support that reincarcerating people for technical violations of probation revocation decreases recidivism. Currently, the recidivism rates for probation, and this is through the Interagency Council that the AGs is a part of, probation, parole, public safety, is approximately 54%. 54%. So almost half of the people who are on probation have recidivism rates. Now, included in that count is technical violations. So if we not reincarcerate people for technical violations, one, it saves taxpayer dollars. We can then divert the funding that would be spent on incarceration into community-based programs that were just highlighted earlier today to keep people in the community. Now, the earned time credit system, we would support an amendment that it would be a 30-day compliance, then you have 30 days decrease reduction in your probation term. So over a period of time, it would reduce the number of people on probation and the length. Now, there is a provision in the draft, the earlier draft, that if someone then violates a term and condition of probation, that they could have those 30-day earned forfeited. So that is another sanction that can be used, again, to support compliance, and if someone's not complying, to have that taken off the table. The other thing that we'd like to highlight is that there is a provision in the bill originally about having individuals moving to or being required to go to another island for treatment. We understand that on some neighbor islands, there isn't always treatment available. So we can understand if that provision is removed. And ultimately, because this is a
Could you
system,
summarize? I'm sorry.
if this is a system, this is a systems change, what we recommend is that the judiciary be given time to implement this through probation. Some other states that have implemented this have had a wait period of 1 year up to 18 months to create the database systems that would automatically calculate the earned time credit. Please support this measure. Thank you so much.
Thank you. Okay, are there any others on Zoom that would like to testify? If not, there were a total of 21 in support, 2 opposed, and 1 with comment. Numbers question.
Yes. Thank you. Not quite sure who to ask. Maybe I'll go to Kat because I know her. I should give a straight answer. I think in the original committee report, it said that they wanted to pull out the technical violations clause due to a lack of specificity of what it means. And I'll confess, I'm not sure about all the details of this. Is there, you know what that was in reference to? Because it said we'll take it out now so that the definition of technical violations can be worked on as the session goes forward.
They know what technical violations are: not showing up for a meeting with your parole or probation officer, missing meetings, moving without advising of your address, dirty UAs. I mean,
Is there a way to define it? I mean, I'm just saying that's why it was in the first committee report to change and pull that out. So.
well, I guess we could enumerate that, but
It'd be a long list, probably.
yeah, it just,
Is
purpose of
there any?
probation is to get people to be compliant, right? So that they can be in the community safely.
Well, is there a way that people could dispute and say, well, I got thrown back in, because of a technical violation, when maybe from the other side, the parole officer said, well, it wasn't really technical, it was, more substantive. I don't know.
Well, they would have to actually say what that was before they incarcerated somebody. It would have to be more than just we have too many people in prison for technical violations, and it's not helpful.
You got it?
Definition of.
Okay, I'm just pointing out that's why it was peeled out, and I see everybody saying, put it back in, let's not send them back in for technical violations. And I don't know the issue well enough, so that's why I'm asking.
Prison is expensive, and it actually promotes criminality. So
Yes.
to me, it's not the best option. Should be the very last resort.
Thank you. Thank you, Chair.
Okay, otherwise, we'll move on to House Bill, the final bill. We have House Bill 2169, House Draft 1. And we have Lee Hayakawa, Office of the Public Defender.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Assistant Public Defender Lee Hayakawa. The Office of the Public Defender strongly supports HB 2169 HD1. The Office of the Public Defender, however, urges the committee to delete the language requiring that the inmate request assistance in the procurement process of a civil identification card. From our standpoint, it would be preferable that assistance is presumed and the inmate should be allowed to opt out of the civil identification card process if they so choose. This measure will potentially give parolees a head start to becoming contributing, law-abiding, and upstanding members of the community. Thank you for the opportunity to comment on this measure. I'm available for questions. Thank you.
Thank you. Mark Patterson.
Pretty quick. The commission wants to add its comments in opposition of the bill. Though we understand the intent of the bill, it's important for you folks to understand in our role as overviewing the comprehensive offender program of Department of Public Safety that in order for reentry to be really successful, there needs to be the identification documentation assurance of having that prior to release while they're incarcerated. Birth certificates, social security numbers, IDs are best done while they're incarcerated so that upon release, employment is easier, education opportunities, transportation opportunities, banking, financial, federal, state services, all that which requires identification. All of this should not be left up to the decision of the offender in order to get those documents in order. It should be done as the first step for reentry planning for the offenders within the system. I will be here for any further questions. Thank you.
Max Otani, Public Safety.
Hi, good afternoon, Chair, Vice Chair, Committee members. Max Otani, Director, Department of Public Safety. We strongly support this measure. And this measure basically clarifies our role in assisting the inmates to get identification. Currently, state identification is the responsibility of the Department of Transportation, which it was, the responsibility was delegated to the counties, and it's through the years that we have been trying to replicate state IDs, we found that we do not have the authority to produce the state ID. So currently, we are working with the city. We have the machine to, scan documents to the city. The city will receive those documents, review those documents, print the IDs for us, which we will obtain. I think the question in this measure regarding the assistance that the inmate, gives us request assistance. I think if you read that, the whole phrase is basically that they request assistance of being notified that assistance is available. So we would need the inmate's assistance in getting these documents. If the inmate does not want to assist us in providing information as to where he was born and his family's name and all of that, it would be very difficult or impossible for us to get those documents. I would be available for any questions you may have. Thank you.
Thank you. Okay, we have Carrie Ann Shiroka. Carrie Ann.
Aloha Chair, Vice Chair, members of the committee, Carrie Ann Shiroka on behalf of the ACLU. We support individuals receiving civil IDs prior to release into the community. So for that matter, we do oppose this bill the way it's drafted. We believe that it would water down the department's responsibility to provide civil IDs to people exiting our jails and prisons. The U.S. Department of Justice has recognized that the provision of identity documents is being critical to successful reentry. The law has been on the books since 2017. Years have passed, and yet people are leaving without IDs. If you don't have an ID, you might not be able to access things like housing, other types of benefits, even getting your prescription medication, which sets people up on a pathway for failure or significant barriers to success. I would like to highlight that there are other states. The Georgia Justice Project has a breakdown of all 50 states in terms of providing IDs for those exiting jails and prisons. A few of them should be highlighted. Ohio has a policy that they provide an inmate release card to all eligible persons upon their release. In Oregon, the Department of Transportation, DMV, and the Oregon Department of Corrections have established through interagency agreement the following program to help a person obtain a driver's license or identification card prior to his or her release from custody. In Michigan, they launched a new program to ensure that all people leaving prison have a state-issued identification card, and if eligible, are also registered to vote. In California, there's a provision as well that they provide all individuals leaving prisons and jails with an identification. If this can be accomplished in other states, I'm confident that we can do it here by the different agencies working together, and that we can overcome whatever barriers are in place. But the law has been on the books since 2017, and sadly, we're almost 5 years later. We're having a bill that potentially can water down their responsibility, and we ask that we place the burden upon the Department of Public Safety. And ultimately, if the department is not able to positively ID a person, whether it's in our jails and prisons or the state mental hospital, we may be having people incarcerated and detain the wrong person. So let's again put the burden back upon the Department of Public Safety to provide this important tool for successful reentry. Thank you.
Marianne, before you get off, I think Senator Revere had a question. I think maybe you could answer it for him.
Yes.
On the last bill.
The last bill.
Oh.
Bill for this.
Okay. Thank you, Chair. With your indulgence, I'd like to go back and ask a question on the technical offenses that send people back. Is there a definition or a better way for this committee to understand or frame what is a technical offense? Noting that the first committee pulled it out because of what that chair perceived as an ambiguity.
Yes, so I was there for that committee hearing, Senator, and there was some confusion on the part of the committee members. But if you look at the statute in the past, and we have online with us, right, public defenders as well as probation, so they can always clarify because they have the greatest expertise. But the way that technical violation, if you have a condition and term of probation, it's usually there's an order of what you can or can't do. If you violate that, for example, a curfew was mentioned, if you have a positive urinalysis for using drugs, if you don't report a change in job, you've absconded, you've missed some meetings, it could be a compilation of these technical violations. So it's any term and condition. The other way that we look at it is this: if someone has a new conviction while they're out on probation supervision, we can understand that someone may be incarcerated for that possibility. This is focusing on technical violations for a condition of probation that is not a new conviction. But again, probation staff here as well as public defenders can clarify that point.
So on the other hand, then what is a violation that is not technical? Why would you violate your parole? What are some other reasons that would be violating parole but are not technical?
So Senator, if for probation, if someone, again, let's say somebody is arrested for maybe a new crime, and if they are convicted of that, that would not be a technical violation, that would be a new conviction that they could move to revoke probation for that reason. Again, Lee Hayakawa, who's on here, and Brooke from probation could, I think, more specifically give you concrete examples because they were
a new crime, but then why even have probation? If maybe that's your point, but why even have probation if everything's a technical violation?
You know,
Senator, the new crime's a whole separate thing. That's unrelated.
Yeah, Senator. So, and this kind of goes back to the data point. I'm sorry, we did submit a supplemental document that actually compiled data from 2014 to 2020 that shows sort of the arc of probation violation from 2014 year by year to current. And if you look at 2014, this is pre-pandemic, there were less people revoked inside of our jails and prisons for probation revocation than last year, December 2020, in the height of the pandemic. And so we are saying, looking at these data trends, it is concerning for us that we are incarcerating people for technical violations and that we're not providing incentives for compliance. That is the crux of this bill.
Beyond, I'm sorry, beyond a new crime or something.
Yes.
What is a violation of the terms of probation that is not technical? What is an example of that?
So to answer the question, my understanding again is if they have a new conviction, that would be something that's not a technical. I'm sorry. That is that is also something that they can revoke somebody because they're not supposed to have new charges, for that reason. But again, our position from the ACLU is that if someone is relapsing, and I can point to data from probation, they mentioned that most of the people who are revoked because of relapse. And we're
Is there a
saying,
way, pardon me, is there a way to structure probation where the probation clarifies what is serious and sends you back and what is technical? Is there a way to create a better expectation coming into probation? Maybe that
yes.
we get to.
So there could potentially be a tier process. I think it would, maybe you're implying potentially other states may do it in other ways, and probation could speak to that. But from, again, we want to highlight most of the people with technical violations are relapsing. And why would we keep incarcerating people for a public health issue? And when people are detained, they typically do not receive substance use treatment. And as we know, people are using drugs in our jails and prisons. It's a very expensive response to relapse, Senator.
Okay, well, thank you. I don't want to bog down the hearing, but thank you very much. Thanks, Chair.
We'll explain it to him further. Yeah, we'll meet with him separately and explain it to him.
On this one,
On the probation issue.
oh, no, just everything that Carrie Ann said is true. We're just incarcerating people for.
Could you maybe after this session, maybe
Explain to the senator.
Yes,
yeah.
I will.
Senator Rivera.
I will.
Okay. Thank you.
2169.
1169. Okay,
You're on Mr. Leverett.
yeah, that's where I was. Nicholas, are you there? Nicholas.
Yes, still here. Great conversation. Nikos Leverins on behalf of Hawai'i Health and Harm Reduction Center. We support this bill, although we also align with the comments of prior parties that, identification documents should be a given for people being released from prison. And we support this bill insofar as it encourages the Department of Public Safety to do what it's not currently doing. But when people are released without identification documents, it is really difficult to get them access to services, including housing. And without that sort of support, the recidivism rate is going to be very high. So identification is critically important for pre-release planning. Thank you very much.
Sandy Ma.
Good afternoon, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. We provided comments on HB 2169. We do support proactively providing assistance to those who are incarcerated with obtaining civil identification documents necessary to transition into the population. We do have a question and concern about how these civil identification documents are provided. And our concern mostly has to do with automatic voter registration, which was passed by this legislature last session. As the ACLU pointed out, Oregon, which allows for providing civil identification documents to incarcerated individuals, also interfaces the AVR process and makes sure that people who have the ability to vote are also registered to vote. And we are all vote by mail state, and we are a state which has a wonderful laws in the books for incarcerated individuals who are on probation and parole. They do not have to finish out their probation and parole sentences and to still be able to vote. So we want to make sure those people who get their state IDs are also registered to vote through AVR, which covers civil identification, state identification. And so I just wanted to clarify as to how that will interface with AVR. Thank you very much for allowing comments, and I'm available to answer any questions. Thank you.
Thank you. Peter Colatorch.
Thank you, Chair. I would like the record to reflect that although I was scheduled to simply provide comments on this bill, I have since revised my position and will be speaking in opposition of HB 2169. Initially, I thought this bill was an opportunity to secure the implementation of a commitment made some 5 years ago by the Department of Public Safety to provide effective and comprehensive reentry planning and to issue civil IDs to people exiting jails and prisons. And I'm still committed to the idea that working with folks to make that reentry plan and giving them the documents they need is a baseline level of support that benefits all parties. And if we want to keep people out of jails and prisons, we should be working with them to maximize the likelihood that they're able to find stability back in the community, which is, something that's incredibly difficult to do when you exit and you are then exposed to discrimination, housing, employment, and access to programs and social services. So, bottom line, we need to help these folks in providing legal documentation is kind of a baseline function that PSD should be filling. And right now they're not. So we should be pursuing programs and laws that will help get those documents in folks' hands rather than weakening the need for the department to provide them. So thank you for allowing me to testify.
Thank you. Any others that are on Zoom? Or I guess those in the room who may want to testify can come forward.
Well, this has been a long time coming.
Yeah.
And it's been quite a process. The department actually got a machine and it didn't work and they couldn't figure out how to make it work. So this administration with Max Otani and Tommy Johnson actually went to the Department of Transportation Services in the city to say, how do we do this? So they made a memorandum of agreement. So they now have a satellite computer like the same kind they have in satellite city halls. So the department puts in or scans in the documents and then it goes to the city. They create the card, the ID card, and then the department will go and pick it up. When I first read this bill, I was like, oh, good, finally they're doing something. Then I read that part about, well, the person has to ask for it. And I thought, that's not good. We have 8 different languages spoken in our facilities. And, it's really important that people understand what's happening. So the department sometimes just puts stuff on closed circuit TV. And for a lot of the people who cannot read, that's not real helpful. So we have a suggestion that they actually create some kind of form and in languages of the person that they're trying to get information from, and distribute that so that people will understand why they need ID and what kind of documents they need. Because people don't really know that. If you've been in prison 10 or 20 years, you don't know what you need when you come out. So I called the department and said, what's up with this? And I was told basically what I just told you, that they do now have this machine, they are able to do it, but I want them to have more one-on-one contact with the people. And what I was told by the director is that the cards that they pick up will go into the person's file so that when the person is released, they're not going to do everybody at once. They're going to do mostly the people who are coming up for release, and then they will give them the cards.
Is that your suggestion, that the form should be in languages other than English?
It should be in the different languages of the person who's supplying the documents. Because we speak like Chukis, Hawaiian, Ilocano, Tagalog, Samoan, Tongan, Vietnamese. So we want people to understand. Thank you.
Can I just ask a
Sure,
follow-up
ask the question.
So does the prison system have people on staff that could do that, or do we need to point them in the direction
Good
of
question.
where
I
they can
asked
get it
the
done?
same question. I said, what about, somebody who speaks Tian Viet? Do we have staff members who can speak that? And they said, well, we go through the population and we see if there's another person who's incarcerated who speaks that language, who can talk to that person. And I said, okay, so what if you can't find somebody? Then they provide an interpreter, and I assume they go to the Office of Language Access.
Probably. Okay, thanks, Kat.
Siri. Yes.
Yeah, ask Siri.
Good at conversion language.
Yeah, good on the phone.
Oh, you're up there, Kat. Answer, lady. One would presume that if they've been arrested and convicted and put in jail, we actually positively know who they are. One would presume that, right? So
One would, yes.
notwithstanding maybe somebody from a foreign country where there's different documents, it seems to me anybody, at least from this country, there really shouldn't be an issue getting additional ID or reissuing the ID.
Well,
So-
first of all, when somebody's arrested, you have like 30 days to have somebody pick up your personal belongings, or else they're tossed out.
Yes, but we verified, I mean, when we threw them in jail, we presumably, we're without a doubt who they are. And
Yeah.
so their identification should not be in
Well,
doubt.
this is a little bit more because it's birth certificates, social security, it's the whole ID thing more than just the card.
But there should be then, we know who they are, there should be a way for the prisons to get that information to assist them, yes? I mean, that's,
Yeah, you know, one of the things about reentry is you try to make people be as independent as possible. So you tell them you're coming into the community and you're going to need certain documents in order to get into federal buildings or state buildings and, you know, that kind of stuff. So
okay,
I think they're doing it the right way, finally.
okay,
but,
great.
It's a long time coming.
Yes, thank you. Thanks, Chair.
Thank you, Kat. Okay, members, any questions? Otherwise, we'll go into the deliberation. Yeah, do we need to count?
The numbers of.
Oh, yeah, okay, okay. Let me give you the count of what it was on the previous one. Okay, we had on this particular measure, I think it's 2309. There was 27 in support, 1 opposed, and 3 comments.
Yeah.
Oh, okay, 23,
21.
2169. There were 15 in support, 2 opposed, and 6 comments. I think that pretty much wraps that one up. Okay, members, otherwise we'll go into recess. Okay. The Committee on Public Safety is back into session again from the recess. Committee members have been given the amendments as suggested. And so, any members, any questions about them? No, otherwise, we'll go into the vote. I'd like to note that I'm going to get to a particular bill where I have additional comments. I will note it for the record. Okay, we can start with House Bill 1739, House Draft 1, is to pass it as is. And House Bill 2309.
Wait. Let's take the vote on
Yeah.
17.
Oh, yeah. I'm sorry. Getting ahead of myself here. Everything to vote. There goes I.
Members voting on HB 1739, Chair's recommendation is to pass on amended. Chair votes aye, Vice Chair votes aye. Senator Baker.
Aye.
Senator Rivera.
Aye.
Senator Favela.
Aye.
Chair, your recommendation is adopted.
Okay, thank you. Next is House Bill 2309, House Draft 2. We're going to pass it with amendments. Although you folks have it before you, anyone?
Recommended by ACLU.
Okay, these are the amendments recommended by ACLU. Provide an appropriation for the Department of Human Services for the development and maintenance of diversion, reentry, rehabilitation services and programs by nonprofit organizations within the state. Also to provide an appropriation for the Department of Health for the development and maintenance of diversion, reentry and rehabilitative services and programs to nonprofit organizations within the state. And then require state agencies and nonprofit organizations under this measure to submit an annual report to the state legislature outlining how the funds have been expended, the list of providers, how many people have been served, and the description of services and measurable outcomes. Okay, so it's passed with amendments as stated. Chair goes aye.
Members voted on HB 2309, passing with all those amendments. Chair votes aye, Vice Chair votes aye, recognizing all members here. Any reservations or nays? Seeing none, Chair, your measure is adopted.
Thank you. House Bill 2312, House Draft 1. We have amendments as recommended by the Women's Prison Project. On Section 2, add one commission member who represents the Office of the Public Defender. Section 2, clarify the appointees to the commission may come from any county in Hawaii, not just Honolulu. That's with amendments. Chair goes aye.
Members voting on HB 2312, HD1, Chair's recommendation is passed with amendments, recognizing all members here. Any reservations or nays? Seeing none, Chair, your measure is adopted.
Thank you. House Bill 2344, House Draft 2, there are amendments as recommended by the Office of the Public Defender. Provide for good time credit system. Formally review conducted by the probation officer, and the probation officer must submit a report after the formal review of the defendant to the presiding sentencing judge, and should be required to justify the defendant continues to need supervision on parole, and reinstate the term technical violation. Requires a written notice and not a bench warrant, and arrest when a minor technical violation has occurred. Include the proposed amendments by the ACLU, where a defendant shall earn a credit that is worth a reduction of 30 days from the defendant's sentence for every 30 days that the defendant is in compliance with the conditions of a sentence of probation. And also the judiciary recommended that the review early termination be conducted on the probation cases, with the exception of cases involving habitually operating vehicles under the influence, possession of firearm, domestic violence, and temporary violation of temporary restraining orders, and abuse of household members, and crimes against persons, sexual assault and violence involving minors. These types of cases involve deceased victims and their families who have suffered psychological trauma. So these are the ones that will impact the early termination. Also, let's see. I think something else I wrote down as well. Also, I think under ACLU asks that multiple strategies be to reduce the length of probation and reduce the caseloads of probation officers and reduce revocation rates that result in incarceration for technical violations of community supervision. So, yeah. Can we take a vote on this one with amendments?
Members voting on HB 2344, HD2, passing with amendments, recognizing all members here. Any reservations or nays? Seeing none, Chair, your recommendation is adopted.
Okay, and the final measure is House Bill 2169, House Draft 1. We're going to pass it with amendments suggested by the Public Defender and the Hawaii Correctional System Oversized Commission, which removes the language found on page 2, lines 9 to 11, which reads, provided that the inmate requests assistance after being notified, assistance is available. So we replace that with Department of Public Safety will be required to provide inmates with civil identification cards upon release with the assistance of the Department of Transportation, and to create forms in the languages other than English for those who are to receive that.
Additionally, did you want to put in that comment that the provisions of should not be construed to this far, anybody does have the right to vote?
Yeah, right, the clarification. Good. Okay, we all clear on that one? Ready? Okay, so are we ready to vote on that one? Ask for the amendment.
Members voting on HB 2169 HD1, Chair's recommendation is to pass with amendments, recognizing all members here. Any reservations or nays? Seeing none, Chair, your recommendation is adopted.
Thank you, members. This concludes the hearing.